Hey everybody, it's January 16th, 2019. We're here at the my law office, J. Ryan Brown Law in downtown Noonan. And today we're going to talk about bond. And I have a podcast episode out about bond, but I just wanted to do a shorter video discussing two things about bond, and they're kind of coming in fours. So we're going to talk about the four things a judge considers in setting bond, and then the four different types of bond. So if you get a bond, then what are the four ways you can post bond? So let's start with the things a judge considers. So when you're arrested, many times the first thing somebody's worried about is, can I get a bond? When will I get a bond? And everything like that. For a more in-depth look at those things, please check out the podcast, Georgia Criminal Law Podcast. Episode 2 is about bonds, and it's a half-hour discussion on the different kind of court dates that you can get bonds at, how your attorney can file for a bond, what happens at bond hearings, everything like that. But this is just going to be a shorter description. So if you have any more questions about anything we talk about today, feel free to check out that podcast or give me a call at 470-635-1725 or visit the website at jryanbrownlaw.com. All right, so let's get started. Let's say we're at a bond hearing and your attorney and you are you're fighting, you want to get out of jail while you're waiting trial. You really want to get out, you want to be able to help your attorney prepare your defense. What are the four things a judge is going to consider in determining whether or not to set you a bond? Number one, the judge wants to know if you are a significant risk of fleeing the jurisdiction. So, where do you live? Do you live out of state? Do you live far away? Or do you have roots here? Let's say your case is in Coweta County here in Noonan. If you live in Coweta County, your family's in Coweta County, that lowers your risk of fleeing because you have ties here to the community. You're not as likely to flee. Now, let's say you are from Florida or from Tennessee or South Carolina or Alabama or Virginia or New York, and you just got in trouble while you were passing through. That makes the risk of fleeing a little higher. Your home's not here, and things like that. Now, just because you don't live here doesn't mean you can't get bond. There just means that you need a little bit more creative arguing. You need your attorney there may be required additional conditions on your bond, whether it be a GPS monitor or house arrest or anything like that. So that's the first factor a judge considers in determining whether or not to set your bond, and that is, are you a significant risk of fleeing? Second, are you a threat or a danger to any person, the community, or any property here in the community? So the judge makes an assessment about basically whether you're dangerous. Was it a violent crime you're accused of committing? Is there a risk of you damaging any property or anything like that? Are you going to be a threat to society while you're out on bond? The judge has to consider that. That's the second one. Now, the third one, it kind of relates to the second one in my mind because prosecutors often use your criminal history in arguing both the second and the third factor. So the third factor is, do you pose a significant risk of committing another felony pending trial? So prosecutors will use your criminal record to argue, if you have a criminal record, to argue that not only are you a danger to society, a danger to community, and that you also are a threat of committing more felonies. Now, I'm just letting you know that there are tools. That's a tool prosecutors use. Now, the coin has two sides in that if you have a clean criminal history and a light criminal history, then that's something your defense attorney can really point out to the court and to the judge and say, look, judge, this is a wrong place, wrong time kind of thing. You may even have the wrong guy. There's no risk to the community. There's no risk to the property. There's no risk to any people in this community. And my client, there's no chance he commits another felony while he's out on bond. The fourth and final factor a judge considers in determining whether or not to set bond is if you are a risk of intimidating witnesses while you're out on bond or obstructing justice. So there are certain kind of cases where this comes up more often than others. For instance, in drug cases, there's no real victim. There's no victim at all in drug cases, and so there's no victim for a defendant to threaten or to intimidate or anything like that. Whereas in gang cases, you see prosecutors oftentimes saying that gang culture precipitates threatening of witnesses, and you will also see prosecutors argue that witnesses are at risk of being intimidated in domestic cases, where a lot of times if someone is given bond, they are back to live with the complaining witness or the alleged victim in the case. So those are two types of cases that you really see prosecutors harp on this factor in setting bond. So, like again, the fourth factor is a significant risk of intimidating witnesses or obstructing justice. And the two kinds of cases you really see prosecutors harp on this factor are going to be one, gang cases, and two, domestic violence cases. So those are the four factors. Let's go over them real briefly. Are you a substantial risk of fleeing? Do you pose a threat or danger to any person, community, property in the community? Do you pose a significant risk of committing further felonies while you're on bond? And are you a risk to intimidate witnesses or obstruct justice? Those are the four factors in setting bond. All right. Now let's say the judge does set you bond, and you are given, let's say, a $10,000 bond. What are the options for posting bond? So if you're given that $10,000 bond, there are generally only three options to post that. One's a cash bond. So if you have $10,000 cash laying around, or your family does, they can literally post that $10,000 cash and have you released from custody pending your trial. And as long as you show up to all your court dates, that should be returned at the conclusion of your case. Another option is a property bond. You'll need the deed from the property, as well as everybody who's on the deed to agree to post a property bond. You're going to need to contact likely the sheriff's office where the property is located, get that property posted. Now, you're also going to have whoever the owner of the property is who's posting it for you as bond, they're going to have some equity in the property, likely 2 or 3 times the amount of your bond value. So if your bond value is if your bond is set at $10,000, you're likely going to be required to have $20,000 or $30,000 in equity in that home or property and able to post it as a property bond. Now, third, and there's a fourth type of bond that's a little unique. We'll do it last, but the third option for posting this $10,000 bond would be what's called a surety bond. Now, these go through bonding companies. You see there's many bonding companies in town and all over the state, and it's a surety bond. And basically what that means is you pay this bonding company a fee, and in exchange they post the $10,000. Now, your fee is likely going to be between 10 or a little bit more than 10% of the bond. So let's say it's 12.5%. You're going to be looking at paying $1,250 to a bonding company to post that $10,000 bond. Now, the bonding companies have to make money too, so you're not going to get that $1,250 back. Okay, you're paying a fee to get the bonding company to post your bond for you. All right. Now, those are only 3 ways. That's a surety bond, which is a bonding company, a cash bond where you post actual cash, and then a property bond where you post property. I told you earlier we were dealing with 2 sets of 4. So what's the fourth one? The fourth one is a little different and extremely rare in felony cases. Okay, it's a OR bond, or own recognizance bond. Basically, what that means is the judge lets you sign out of jail, and when you sign, you promise to come back. You see that more often in low-level misdemeanor cases, and even then it's pretty rare to get a signature bond or an OR bond. But if circumstances are right and the opportunity presents itself, occasionally a judge will grant an OR bond where you can literally sign your own bond, and your signature, your word that you're going to come back, the judge deems sufficient to ensure that you're going to return to court. So today, that was bond. That's the 4 things judges consider in setting bond, and the 4 different kinds of bond. If you have any questions, of course, consult an attorney if you're looking to have a bond hearing and get bond out and get out of custody while you await trial or the resolution of your case. Again, I'm Ryan Brown, J. Ryan Brown Law, LLC, here in downtown Newnan. We're located at 19 Perry Street, Suite 202. It's the commercial house right behind the big post office and the federal courthouse. Visit our website at jryanbrownlaw.com, and feel free to give us a call at 470-635-1725, and hope everyone has a great day. Thank you.